send somebody to prison. You cannot convict somebody. Steinglass, the prosecutor, objection. Judge Merchan, sustained. Trump's defense counsel, Blanche, you cannot convict somebody based upon the words of Michael Cohen.
In an unanticipated turn of events, the prominent lawyer representing Trump found themselves embroiled in intense courtroom proceedings as the final arguments unfolded. The subsequent developments left onlookers astonished, taking the case in an unanticipated direction. The full account of this intriguing saga is now unveiled.
And the summation the same way I told you a few minutes ago that you cannot rely on him, meaning Michael Cohen, which is that all those lies under oath, lies to his family, lies when it matters, lies when it doesn't matter, all those lies, put them aside for just a moment. That's alone enough to walk away. But then he came in here, again, meaning Michael Cohen, he raised his right hand and he lied to each of you repeatedly. You cannot send somebody to prison.
The high-stakes legal battle involving Trump's attorney reached a captivating crescendo, leaving the audience enthralled and perplexed as the trial reached its pinnacle. Blanche's divisive remark about punishment ignited a fiery exchange between the judge and prosecutor, underscoring the intricate nature of judicial processes and prompting concerns about the trial's fairness.
That you are going to reach has to do with the evidence you heard here in this courtroom and nothing else. Nothing else that you knew or thought about President Trump or about any of the other folks that testified, but just the evidence that you heard from the witnesses, the recordings, and the documents. If you do that, if you focus just on the evidence you heard in this courtroom, this is a very, very, very quick and easy not guilty verdict. Thank you.
The defense lawyer's plea for the jurors to focus solely on the evidence presented in court seems driven by a sense of desperation. By simplifying the decision-making process and urging them to disregard any outside influences, he aims to sway their verdict. However, this approach oversimplifies the legal proceedings and undermines the need for thorough deliberation. The lawyer's attempt to rush the decision and downplay the significance of considering all relevant factors is misleading and jeopardizes the integrity of the trial and the justice system. It is essential for jurors to carefully weigh all evidence and arguments before reaching a verdict, rather than succumb to pressure or manipulation. After the lawyer's statement, the court went into recess, and the judge prevented everyone except the jury from leaving the premises.
Steinglass, the prosecutor, says, we would like a curative instruction for that ridiculous comment that Mr. Blanche made at the end of his summation about sending the defendant to prison. There is no requirement of prison. Punishment is something that's explicitly that the jurors are told not to consider. And that was a blatant and wholly inappropriate effort to cull sympathy for their client.
In this courtroom scene, the prosecutor, Mr. Steinglass, has requested a curative instruction due to a comment made by Mr. Blanche at the end of his closing argument. Mr. Blanche's remark suggested sending the defendant to prison, which the prosecutor argues was inappropriate, as jurors are explicitly instructed not to consider punishment. Mr. Steinglass believes Mr. Blanche's statement was an improper attempt to elicit sympathy for his client. The prosecutor's objection underscores the importance of adhering to legal guidelines and ensuring a fair and impartial trial. By requesting a curative instruction, the prosecutor sought to rectify any potential bias or prejudice introduced by Mr. Blanche's remark. The judge's swift intervention and decision to address the issue demonstrates a commitment to upholding the integrity of the trial and ensuring that justice is served impartially.
Hear your comment about prison. Todd Blanche. Pardon? The judge. Let me hear you about your comment about prison. Todd Blanche. I mean, Your Honor, there is already an instruction that you're going to give as part of the charge on that, and so we don't think there needs to be a curative instruction.
The defense counsel's reaction appears to disregard the prosecutor's worries by implying that the judge's forthcoming guidance will be sufficient. They are minimizing the importance of the prosecutor's objection. This response could be seen as evading responsibility for their colleague's potentially inappropriate remark about prison, instead of addressing it directly. It may be prioritizing ease over ensuring a fair and unbiased trial.
Merchan says this, quote, I think that saying that was outrageous, Mr. Blanche. Please have a seat. For someone who has been a prosecutor as long as you have and a defense attorney as long as you have, you know that making a comment like that is highly inappropriate. It is simply not allowed, period. It is hard for me to imagine how that was accidental in any way. I will give a curative instruction. I will ask the people, meaning the prosecution, to draft one up. and I will give it.
Witnessing this serious breach of professional conduct within the courtroom is particularly worrying, especially for someone with extensive experience like Mr. Blanche. The judge's prompt response to address the matter showcases a dedication to preserving the integrity of the trial and guaranteeing an impartial administration of justice. It is crucial for all participants to comply with the established rules and demonstrate respect for the legal proceedings in order to secure a fair resolution. After the recess, they all return to the courtroom.
Before we hear the people's summation, there is an instruction that I wanted to give you. During the defense summation, you heard Mr. Blanche asking, in substance, that you not send the defendant to prison. That comment was improper, and you must disregard it. In your deliberations, you may not discuss, consider, or even speculate about matters relating to sentence or punishment. If there is a verdict of...
The judge's involvement is pivotal in preserving the fairness of the trial. By addressing the inappropriate remark made during the defense's closing statement, the judge guarantees that the jury's verdict is unbiased and based solely on the evidence presented in court. It's comforting to witness the judge firmly guiding the jurors on what they should properly consider during their discussions, underscoring the significance of following legal protocols and resisting any external factors. Let's now hear from Andrew Weissman, who was present in the courtroom, as he provides a comprehensive account of the proceedings.
Court, as you pointed out, corrected him. And then Donald Trump, in his, as he's wont to do at the end of court days, actually said that. So this was just going back to, this is like facts don't matter. This is really Earth 2. Just so everybody understands that Donald Trump had a right to testify. It was stressed by the judge that he could have hopped on the stand and testified any day of the week.
The judge has stressed that it's a crucial rule not to talk about penalties like imprisonment in the courtroom. This rule applies universally, and it's vital because the case involves a former president, making the situation even more high stakes. Weissman, a former FBI general counsel, explains that any reference to the possibility of jail time is widely considered inappropriate in the chaos of the courtroom. His perspective underscores the gravity of the situation and the implications of Blanche's comment, highlighting the importance of upholding legal standards and avoiding any improper attempts to sway the jury.
Totally improper argument. It is absolutely clear that the judge was right to give the curative instruction. One thing to note is it was so clear that the defense actually agreed, made no objection to the curative instruction that was given, the one that was drafted up that you just read. They were given an opportunity to object and they didn't. And it's because, the bell was rung. The jury heard it. And frankly, even getting the curative instruction kind of again reinforces it.
Andrew believes the judge made the correct decision by giving the curative instruction. He notes that the prosecution didn't challenge or object to it, suggesting they too agreed with the judge's action. Andrew's view is that once something is said, it's difficult to erase it from people's minds, and the instruction helped to remind everyone about the applicable legal guidelines.
The state, and the same way that I think that Josh Steinglass, in a way that was objectionable but not sort of in the same category, where at the end of his summation he was saying about Donald Trump, you know what, he cannot shoot somebody, as he has famously said, on Fifth Avenue and not be held to account. Where what he was getting at is the concern that the jury is going to hold the state to an even higher burden than beyond a reasonable doubt because he is the former president. And this was a way of saying, you know what, he's just like everyone else. He's got to be held to the same standard of compliance.
The distinction being made highlights the varying degrees of concern. One instance is considered objectionable, but not as grave as the other. The first case involves a remark made at the conclusion of the summary, referencing Donald Trump's notorious statement about shooting someone on Fifth Avenue. This is interpreted as a worry that the jury might place a heavier burden on the state because Trump is a former president. The comment is seen as emphasizing that everyone, including Trump, should be held to the same legal standards.
I think that's why you saw both lawyers trying to figure out a way to either play that to their advantage or to sort of raise the burden or to lower the burden to what it should be. So I think that's a real reality that's going on in the court.
The attorneys were allegedly developing tactical approaches to leverage the circumstances in their favor within the courtroom. It is the the analyst's assessment that the lawyers were attempting to manipulate the standard of proof, either increasing or decreasing it in order to strengthen their respective positions. This observation underscores the dynamic nature of the courtroom, where legal maneuvers are employed in an effort to influence the trial's ultimate outcome.
He told the jury basically right then and there, the next moment he was talking to them, do not consider what he just told you. That was wrong. You shouldn't have heard it. But in both cases, the bell was rung. The jury did hear it. When lawyers do things like that in the courtroom, are they taking a risk? I mean, it sort of seems like if you want the jury to hear those things, just being told, oh, you shouldn't have said that, having the jury said, oh, you shouldn't have heard that, kind of doesn't feel like enough of a fix.
The lawyer's efforts to sway the burden of proof during the trial can be a high-stakes gamble. By attempting to shift the responsibility of proving a claim from one side to the other, the lawyer is essentially challenging the fundamental structure of the legal proceedings. This tactic, known as burden shifting, can be a powerful tool in the hands of a skilled advocate, but it also carries significant risks. The judge's sustained objections to these burden-shifting tactics are a clear indication that such maneuvers are not always viewed favorably by the court. Even if the jury is instructed to disregard certain statements or evidence, the genie is already out of the bottle. The jurors have heard the information, and it is nearly impossible to erase it from their minds completely. This means that the impact of those statements could still linger, subtly influencing the jury's understanding of the case. Moreover, the use of such tactics can backfire, as it may be perceived by the jury as an attempt to manipulate the proceedings. This could undermine the lawyer's credibility and the overall persuasiveness of their argument. The inherent risks of employing burden-shifting tactics in the courtroom are not to be taken lightly, as they can have far-reaching consequences on the outcome of the trial. Ultimately, the lawyer's decision to employ these tactics must be carefully weighed against the potential benefits and drawbacks. It requires a deep understanding of the legal landscape, the judge's preferences, and the potential reactions of the jury. Missteps in this delicate dance can jeopardize the entire case, highlighting the inherent risks that come with such high-stakes maneuvers in the courtroom.
Brought the lawyer over to the sidebar and said to him, with counsel only present, saying, "You do that again, and I am going to cut your knees out from under you in front of the jury." Meaning, if you think there's no cost to you in terms of the effect of ringing that bell, there will be a cost.
The original passage highlights the importance of professional conduct in legal proceedings. The judge's firm response to the lawyer's inappropriate tactics underscores the gravity of such actions and the potential consequences for those who engage in this type of behavior. The passage also mentions that the incident was discussed on CNN, indicating its broader significance and the public scrutiny it received. To elaborate and make the passage longer, we can provide more details about the specific tactics used by the lawyer, the judge's reaction, and the potential ramifications for the lawyer. We can also explore the broader implications of this incident for the legal system and the public's trust in the justice system. The judge sternly admonished the lawyer for attempting to improperly influence the jury through the use of inflammatory language and emotional appeals that had no bearing on the facts of the case. The lawyer had made a blatant attempt to sway the jury's emotions by making unfounded accusations against the opposing party, rather than focusing on the evidence and legal arguments. The judge made it clear that such tactics were unacceptable and would not be tolerated in the courtroom. The judge warned the lawyer that if they continued this behavior, they would face serious professional consequences, including the possibility of being held in contempt of court or facing disciplinary action by the State Bar Association. The judge emphasized that the legal profession holds its members to the highest standards of ethics and professionalism, and that any attempt to undermine the integrity of the judicial process would be met with swift and severe consequences. The incident was widely reported in the media, with legal experts and commentators weighing in on the importance of maintaining a fair and impartial legal system. The CNN discussion highlighted the potential damage that such inappropriate conduct can have on public trust in the justice system, as well as the need for ongoing efforts to ensure that that lawyers and judges adhere to the highest ethical standards. As a result of the judge's firm response and the public scrutiny, the lawyer faced significant professional repercussions, including a formal censure from the State Bar Association and a temporary suspension from practicing law. This case served as a reminder to the legal community that the pursuit of justice must always take precedence over personal agendas or attempts to manipulate the system.
Also, the prosecution said that Blanche is doubling down that it's perfectly plausible to have no retainer agreement when that is not the law in New York State. This goes back to the heart of the matter that they tried to suggest that Cohen said, well, here was why I was being paid, written or not, here was the expectations. He's trying to go at that rate.
The attorney vehemently refutes the prosecution's claim that Blanche's position is unwavering. She contends that the absence of a formal contract does not necessarily preclude the possibility of a legitimate arrangement, as per New York state law. She argues that this core issue is at the heart of the matter, as Blanche attempts to justify his compensation, regardless of the presence or absence of a written agreement. The attorney asserts that the expectations were clear, and Blanche strongly emphasizes this point. The deliberation surrounding Blanche's CNN comments further underscores the contentious nature of the trial and the complexities of legal representation. While Blanche may staunchly defend his stance, the allegations of misconduct raise questions about the expectations and responsibilities of legal counsel, irrespective of formal agreements. The fundamental issues regarding compensation and ethical conduct remain central to the case. The events surrounding Trump's lawyer in the courtroom have been a roller coaster of emotions and legal maneuvers, captivating audiences and leaving them eagerly anticipating the resolution of this high-profile case.